And Ms. Moore, can you tell me who you may have testifying today besides Ms. Erickson?
It would be Ms. Erickson and Ms. Sonnenberg. I did get a message from voicemail this morning from Mr. Taylor, and there's a possibility that we might be able to come to an agreement, but I'm not sure exactly the mechanics of how to do that. So when he gets on, maybe the attorneys and the court could discuss things for a few minutes to see if what we're thinking of is a possibility.
Okay. That's fine. Why don't I? Oh, there he is. All three of them are in there. Okay. Are we having meaningful discussion that may lead to an agreement, or we just need to? Okay.
I had a nickel for every time I was muted. We think we are, Judge, but it may be more than we're able to accomplish right at this moment, but I don't know what the alternative would be. So
I have a limited amount of time, and I don't
Yes,
want
sir.
to run out of time, and I don't want to waste my time if we're not going to get anywhere. So
Well, there is some new information given to Mr. Taylor that Ms. Moore just sent to him that he's going to review. So it may be.
okay. All right. And all right. Thank you. All right, let's see here. It looks like everybody's back. All right. There's Mr. Taylor. Can you hear me, Mr. Taylor?
Yes, sir. I can hear you.
Okay. So, do we have any sort of an agreement that we need to announce, or do we need to proceed?
Well, I didn't get back with Terry after I talked to my clients. So I think that CASA and the ad litem are probably want to proceed because they don't want, as far as I can tell, they didn't want that monitored return. I was in agreement with everything, not at first, but now I'm in agreement with everything that you had mentioned.
Okay.
And I think that Terry and I were on the same page, but I'm not
So
sure.
So if the proposal is to, I guess, we'll talk about Levi later. Maybe we can get an agreement with regards to that child. If the proposal is,
I'm sorry, Judge. Yeah, what you said before, as far as Levi goes, let Mr.
okay,
Chapman and I work that out with you in a separate courtroom.
okay. So, did y'all, Mr. Chapman, did y'all talk about what the structure would look like for access by the mother? Did y'all have an agreement on that issue?
No, we didn't get there yet. There he is, Mr. Chapman.
I think we are close to having something worked out there, but I would like to get that firmed up before we just toss the matter to a later date or something.
And
I think.
Okay.
I'm sorry, Judge.
And so if the proposal with regards to Oakland is for some sort of monitored return, I guess the question is, Ms. Keenum, are you going to be in agreement or not in agreement? You can nod or tell me.
Your Honor, I would be in agreement to a monitored return to Oakland and services to be provided to the family.
Do y'all want to talk about that? Ms. Gaiman, do you want to talk to Ms. Keenum about that for a second privately? Okay, so what I'm going to do is put Miss Deborah and Miss Lisa, if you'll go back to room 1, if I give you 5 minutes to get the temporary order with regards to access for Levi, is that something y'all can work out, Mr. Chapman, Mr. Taylor?
I think we had it worked out. What he proposed before that I wasn't sure about, I think we could do supervised visits.
Okay. All right. So
I'd like to do a step, something beyond just a supervision, many.
For today's purpose, we could enter a temporary order with supervised visitation, and then Mr. Chapman could get his pleading straightened out, and we could get a temporary order hearing setting later on.
Okay, I think that we can work that out. I think it's worked out with me and Mr. Chapman.
And Judge, just from the technical standpoint, would you combine that AG case to this, or would I
Hold
file
on.
my
Ms.
pleadings in that?
Damon, you and Ms. Keenum go back to room 1. You're going to have to go down to the bottom of your screen where it says breakout rooms and go back to room 1. Okay, they got in there. Okay, so of course we're off the record, but so the question is, I think,
Where would we put our temporary orders? Would it be in this case, or would it be in that AG case?
so I think the practical way for us to move forward today to get us to 1220 would be to enter an order, a temporary order naming Mr. George as the temporary managing conservator and Miss Jasmine as a temporary possessory conservator, with only those 2 conservators. Keep it in this cause. When we get to the 20th, Mr. Chapman will have filed a motion to modify in the 2019-208 case, and I can on the 20th enter a temporary order in that case, and it would take Levi out of this case, and the department could non-suit as to Levi in this case. At that time, we would have a temporary order in that case. But from today until the 20th, I could enter a temporary order in this case, but the department would not be a conservator. It would just be a temporary managing conservator dad, temporary possessory conservator mom, and on the 20th, we could sever and get everything straightened out.
I'm in agreement.
Okay. Does that make
The only
sense?
thing we haven't done is fine tune what that supervised visit would be, and so we.
Well, I could enter an order that it's visits supervised at the direction of the father, and then y'all could hammer that out to see what it would look like then. And if we want to approve, if you want to propose folks to approve as supervisors, that's fine too. I don't remember Mr. George. I think I don't remember him well enough to remember if he has parents or not that are available for that. But simply a temporary order naming his temporary possessory conservator, temporary managing conservator, her having temporary possessory conservatorship with supervised visitations at the direction of the father. That's a simple solution that y'all can hammer out.
What I had talked about earlier was as approved also by CPS, because I don't want to get sideways with them. So if we say visits
That's fine.
at dad supervised by him or his mother or sister, and CPS is okay, then that works great for me.
I prefer not to. I mean, the beauty of this is that we at least are removing one child from the CPS.
So here's what you can do. You can say, as I've said already multiple times here, supervise at the direction of Mr. George, and Mr. George can confirm who he's having supervised by the department independent of any court order.
Fair, Mr. Chairman?
Your Honor, we can help with visitation as well if Mr. George would like.
Okay, thank you, Ms. Gaiman. All right, so Ms. Gaiman's back and Ms. Keenum's back. Okay, so are we able to move forward, Ms. Keenum?
Your Honor, I have changed my position, and it's my position that the child needs to remain in the custody of the department. Services need to be provided, and what services?
For the boy? For Levi?
No, for Levi, him going with his dad, I'm good. Just this is to Oakland.
Okay, all right.
Oakland would be in the custody. I mean, the conservatorship of the department still, I think, and just a monitored return back to the parent, right, Judge?
I'm not in agreement to a monitored return to the
All
parents.
right, so let me call the case. We'll get Levi taken care of. We can get Mr. Chapman and Mr. George out of here if they want to leave, and then we'll move forward. Okay, folks here with us, I'll identify you. For the record, Ms. Moore is here representing the department as their attorney. Father, Mr. Davila, is present. Mother, Miss Solomon, is here. Mr. Chapman is here representing the other father, Mr. George. Miss Sonnenberg is a case worker for the department, is present. Investigative supervisor, Miss Geis, is here from the department. Mr. George, the other father, is here. Mr. Walker is a supervisor for a conservatorship unit here present. Mr. Taylor is present in his representation of both Miss Solomon and Mr. Davila. Miss Pitcox is our clerk. Miss Erickson is an investigator from the department, is present. Miss Gaiman is the representative of the guardian ad litem Bluebonnet Casa. Miss Keenum's been appointed by the court as the attorney ad litem for the children. She's here. And then, of course, we have the green tea on there, which is Miss Young, our court reporter. All right. Everyone has indicated nodding and said yes, although we were not able to hear everyone. All right. So we had a hearing on October 27th, had to reset till today so we could get legal counsel from Mr. George effectuated. We're here to proceed with our adversary hearing. And so we have an agreement with regards to temporary orders with regards to the child leave. Mr. George is going to unmute here and a second testify. My understanding is that the agreement is that with regards to Levi, the 4-year-old boy, that I am entering a temporary order today naming the father as temporary managing conservator, the mother as temporary possessory conservator, with access at the discretion of the father. And that can be worked out as to where that's going to be supervised. If he wants to get all of his supervisors approved by CPS, he can do that. If he wants assistance from Ms. Gaiman, she'll assist him as well. We'll set the status hearing in the case for December 20th at 9:30 a.m. in person in Brady. And by that time, Mr. Chapman will have filed a motion to modify in 2019-208, the other AG case in McCulloch County that is a final order. So he'll get a motion modified there. And on the 20th, we will enter additional temporary orders if we need to do so, or there may be an agreed temporary order with agreed supervisors and a step-up provision, etc. That's my understanding of this agreement. Ms. Moore, you can either announce or nod that is your agreement.
It is, Your Honor.
And Ms. Keenum.
It is, Your Honor.
And Mr. Taylor.
Your Honor, I'd like to clarify, you said at the discretion of the father. Could we make a minimum, amount of supervised visits? I mean, the discretion would be who the supervisor is.
The
correct?
discretion is as to the supervisor, correct.
Okay. All right. So I would like to nail down how often those visits take place, Judge. Okay.
Can we
We
do
don't have.
4 hours a week,
Okay, Judge. Thank you.
Mr. Chapman?
The 4 hours a week is fine. And yes, that is our agreement.
Okay, and if there's not an agreement as to when, let's just do those on Sunday afternoons from 1 to 5 p.m., but y'all can modify that, okay? So that's the agreement with... Did somebody say something? Okay. As to the child, Levi, the father will be temporary managing conservator, mother will be temporary possessory conservator, and visitation as to the supervisor at the direction and discretion of the father, with the minimum of 4-hour visits per week. And if there's no agreement as to when, on Sundays from 1 to 5 p.m. Okay. So,
Your Honor, that's just for Jasmine, correct? That's not for those are visits just with her.
correct.
Okay.
All right. Now, so let me ask you one question real quick, Mr. George. The law requires that I ask this. Do you have any Native American heritage that would qualify this child for membership in a Native American Indian tribe, to your knowledge?
No, sir.
Okay. So, Mr. Chapman, we've got that resolved. Ms. Moore will put that in a written order for today. Are you going to stick around? Do you want to release Mr. George?
With your permission, Judge, Mr. George and I will step out.
All right. Unless there's an objection, you're excused, and we'll get that in the docket entry, but also in a written order. All right. We'll see you then later. Thank you. I want to ask you the same question about, and you as well, Mr. Davila, any Native American Indian heritage that would mean that your children would be eligible for membership in a Native American Indian tribe? Ms.
On
Solomon?
my part, no.
Mr. Davila?
What's considered eligible?
Well, it depends on each tribe. If you are, so let's say you have Navajo heritage, if your mother was a member of the Navajo Nation, you're eligible for membership. If you heard that your great-great-grandpa used to live in the Navajo territory, I don't know, probably not. Do you know for sure?
No, sir.
Do you suspect that you may be eligible for membership in an American Indian tribe?
Not sure. I would just say no.
Okay. If your opinion changes, let us know, and that just is a law that we have to ask about. Okay. Do you understand?
Yes, sir.
Okay. So, thank you. Both of you can put yourself back on mute. Now, my understanding is that the partial agreement is that the department would remain with regards to Oakland as the temporary managing conservator, and each parent is a temporary possessory conservator. I think the issue is placement if we move forward with the monitored return with regards to Oakland, or if we do not. That is the issue that we have to address today, I think, for our hearing. And so with that limited issue, monitored return with mom and dad, or continued placement outside of the home, that's the issue we need to address, Ms. Moore. Where is Oakland currently placed?
I believe with the mother's sister.
Okay, maternal
Correct
aunt.
on that? Maternal aunt.
All right, so with that understanding, then let's move forward with the determination whether a monitored return needs to occur today or not. That's the standard that we have to meet. So we're really just talking about placement issues. Ms. Moore, you can proceed with the evidence.
Thank you, Your Honor. I'll call Miss Erickson.
Questions?
Thank you, Your Honor. Ms. Erickson, what is your connection to Oakland?
I'm the CPS investigator.
All right. And how long have you known Oakland?
I met Oakland for the first time. I believe it was in May.
All right. So you're familiar with the mother and father and Oakland, is that correct? I mean, before this case started.
Yes, ma'am.
All right. And briefly, what was your involvement then?
There was a case for domestic violence and sex assault against Jasmine from Lewis.
All right. And so the department became involved. Did the department take temporary custody of Oakland at that point?
No, ma'am.
All right. So what happened? How was the department involved?
We did our investigation. We did a safety plan with Jasmine. She had the kids, and we helped her to get her own house. And she was involved with family-based safety services.
All right. And how did her involvement with FBSS go?
She completed everything. It took about 7 months.
Okay. All right. So the department was involved with her for about 7 months in the FBSS matter.
Yes, ma'am.
Okay. And then eventually did FBSS close its case?
Yes, ma'am.
All right. Did something else occur after FBSS closed the case that caused you to become involved again?
Yes, ma'am. The FBSS case closed on the 6th.
Of what month? I'm sorry.
October, I'm sorry.
Okay.
And then we got a new case on the 13th.
Okay. And that was the case involving Levi. Is that right?
Yes, ma'am.
Okay. Now, currently, Oakland is placed with the maternal aunt.
Yes, ma'am.
Okay. And how's that placement going for her?
It seems to be going very well.
Okay.
She's seems to be doing good. She gets to talk to her mom and dad often on the phone. So,
All right. Did they have any face-to-face contact with Oakland?
They FaceTime every night, and I believe that the department has set up visits, face-to-face visits.
All right. And the face-to-face visits, do you recall, is the maternal aunt supervising them, or does the department supervise those?
I couldn't tell you 100%. I know we had talked last court about the aunt supervising, but I'm not sure if she is it.
It's the department.
Is it still the department?
Yes, ma'am.
Thank you.
Okay. All right. Now, in one of the family violence cases, and it was my recollection that was one of the ones from March of this year that involved physical assault and assault. Is that right?
Yes, ma'am.
Okay. And the information that you had at that time was that one of the children was present when that happened.
Yes. When it began, Levi, in a statement to the police, Jasmine stated that the kids were there. And while I was interviewing Jasmine, Levi stated that he was there and he saw Mr. Davila tear his mom's clothes off.
Right. And likewise was Oakland there. Now, Oakland's the younger. Is that correct?
Yeah. I believe she was there. Yes. There's in statements that Miss Solomon made, she was in the bedroom with Oakland when she was actually physically assaulted.
All right. And at this point, then, does that cause the department concern for Oakland's safety?
Yes, ma'am.
Okay. So there's a history of domestic violence, and there's a history of the children being present when that occurs.
Yes, ma'am.
Okay. Is it your position then that, what is your position on a monitored return?
I believe that the family needs to have more steps taken before she can be returned safely.
Okay. So even the requirements of a monitored return might not be enough, at least at the beginning of things. Is that your feeling on this?
Yes, ma'am.
Okay. I'll pass the witness.
All right. Ms. Keenum, do you have questions for Ms. Erickson?
No, Your Honor.
All right. And Mr. Taylor, do you have questions for Ms. Erickson?
Yes, Your Honor. May I proceed?
Yes.
Ms. Erickson, you first said that Jasmine did well and did everything she was supposed to do during the family-based situation after the assaults, correct?
Correct.
And you stand by that?
She did the services that were recommended so that she could be released from family-based safety services.
The whole time, Oakland was with her, correct?
Yes.
We didn't remove Oakland.
No.
And you knew these things that you're telling the court today, you knew that then, correct?
I'm sorry.
You just testified to this egregious thing.
Objection argumentative, Your Honor.
No, I'm
Taylor,
asking her a question.
well, ask her a specific question and let her answer it.
Okay, I'm trying to. I'll get to it right away. Have you changed your mind? I guess because your report doesn't have anything about Oakland at all, correct?
My report. I'm sorry. I don't.
The affidavit for the removal.
Oh, correct. It was the assault. I didn't see any marks or bruises on Oakland.
And you knew about the things you testified to a moment ago about the assault and Oakland being in the house.
Mm-hmm. Yes, sir.
Okay. You didn't testify that she was aware that it was happening. She was there, but you don't know that she was aware that was going on, right?
No,
You
I
don't know.
don't.
Okay.
No.
And in fact, she was asleep. Did you hear that? She was asleep during that?
She woke up, and at some point she woke up per
Okay.
Jasmine's statement.
When she talks FaceTimes with Jasmine and Lewis, she loves them. I mean, she wants to talk to them, correct?
Correct.
There's been no problems as far as the parents speaking to Oakland. Oakland wants to talk to them, correct?
As far as I know, yes.
If this were going to be a problem, what you testified to about Oakland and the assault, wouldn't you have done more in the removal affidavit to talk about Oakland?
Your Honor, I object. Calls for speculation, and he has the ability to cross-examine her now regarding the issues concerning Oakland.
Right. So I'll sustain the objection. I think if you want to ask her about evidence that she has with regards to Oakland, that is relevant, Mr. Taylor.
Thank you, Judge. You didn't state it in your affidavit the way you just testified about not being ready to see a monitor return. I mean, you didn't indicate that you would be saying that today. I mean, it sounds to me like you've changed your mind. Have
Your
you?
Honor, I object. Argumentative.
I'm asking if she's changed her mind. That's a fair
I don't
question.
believe she changed her mind. She
Right.
filed an
Thank you.
That's not for you to say, ma'am.
So
Not for you to
look,
say.
she had her evidence. The department was granted temporary managing conservatorship of both children, and we're talking about placement. If you want to ask her if she's changed her mind, ask her specifically as to what issue you're talking about her changing her mind on. The department, she asked for removal of Oakland in the affidavit. She asked for the department to be named as temporary managing conservator of Oakland in the affidavit. So if there's something you want to ask about her changing her mind, be specific.
Well, let me just change my question. Why didn't you remove Oakland before, during the family-based? Why was that not an issue? If you knew what you know now, why didn't you remove Oakland then, Ms. Erickson?
Mr. Taylor, your question is, if you knew what you knew now, then why didn't you remove her then? I think if she didn't know what she knows now, then. So if your question is, why wasn't Oakland removed at the beginning of the FBSS case, let's ask her that question and move on.
Well, there it is, Ms. Erickson.
I
Judge Hoffman,
apologize.
She froze up and wasn't on the
Yes,
screen
I
for a second.
apologize. I did not hear that
Okay.
question.
So the question, Ms. Erickson, is why didn't you remove Oakland at the beginning of the FBSS case?
I did not remove Oakland because Oakland and Levi were removed from the home with Jasmine. She left the home. And at that point, we were investigating domestic violence against Jasmine by Lewis.
okay. Okay.
We had a safety plan in place. She had a monitor.
And she, for 7 months, she was with her mother. Oakland was with Jasmine.
So
7
was
months.
Levi. Yes, sir.
Right. And you felt they were safe then.
Sir, I was in the case at the very beginning. FBSS would be the one that you would want to talk to about that.
Well,
When I was in the case, I had a safety plan. I had a safety monitor for Jasmine.
And Jasmine had Oakland
Yes, sir.
during that period. Okay. So while you were there, you could have removed Oakland from Jasmine if you felt like she was in danger. Correct?
I had a safety plan in place with a safety monitor to ensure
Right.
that Jasmine and that Oakland, Jasmine, and Levi were all safe.
What you could do now in this situation, in a monitor return, you could basically have the same monitoring device or whatever now. But you don't want to do that now. But for 7 months, it was okay.
Your Honor,
Right.
I think this has been asked and answered.
The,
I don't think
the
she's
question
answered.
is, what has changed? That's the ultimate question, Ms. Erickson. He's trying to ask you, what has changed between the 7 months you were monitoring the FBSS case and now? What has changed?
So what has changed is in 7 months, Jasmine had the kids. 1 week later, she assaulted her son. And admitted that she spanks both the kids with the belt. So what has changed is that it could be Oakland at the next point. That we spent 7 months trying to teach her different ways to handle her children, and yet she reverted back to something that caused injury to her child.
Can I speak?
I'm gonna give you a chance in a moment.
Other
I
questions?
have no further questions for that witness right now, Judge.
Okay. Other questions for Ms. Erickson from you, Ms. Moore?
Yes, just a couple very quickly. During the 7 months of the FBSS case, were Jasmine and the children in the same home with Mr. Davila?
Yes.
Okay.
At some point, yes, they were.
At some point.
Yes.
Okay. All right. And is one of the things that Ms. Solomon was asked to do, that would be parenting classes?
Yes, ma'am.
Okay. And the use of corporal punishment and that sort of thing?
I believe that they go over that, yes.
Okay. I'll pass the witness.
Any questions, Ms. Keenum?
Ms. Erickson, when you got the new intake, were the parents, specifically Jasmine and Lewis, willing to engage the department in services?
No, ma'am.
No further questions.
Mr. Taylor, any other questions for Ms. Erickson?
No, Your Honor.
All right.
Not
And other evidence, Ms. Moore?
I'll call Ms. Sonnenberg very briefly.
All right. She's been sworn. If you'll unmute, ma'am, and state your name.
D. Sonnenberg.
And Ms. Moore has questions for you. Go ahead.
Ms. Sonnenberg, how did you become involved with this family?
I will be the conservatorship caseworker depending on the outcome of this hearing.
All right. And have you had any conversations with either of the parents, Mr. Davila or Ms. Solomon, concerning this situation?
I have met with Ms. Solomon.
All right. During the time that you met with Ms. Solomon, did you discuss her use of corporal punishment with her?
She told me that she had gone through parenting classes and learned different ways of parenting, and said that she had not spanked her children in many months.
Okay. And did she give you some kind of explanation about how the injuries to Levi occurred?
She said that he was climbing in a door frame and fell on his bottom on the floor.
All right. And from what you had observed with regard to his injuries, did that appear consistent based on your experience?
No, the bruises seemed to be linear, which means there was an object involved.
All right. And so did she ever admit to you that this was an issue of corporal punishment, that she had administered corporal punishment to Levi?
No.
Okay. We're hearing about corporal punishment today, but she's made no admission to you of that.
Correct.
All right. And did she say anything to you at all about her intention to keep using or to use in the future corporal punishment on her children?
No.
Okay. All right. Do you have an opinion based on your experience about whether a monitored return is appropriate at this time, or whether the parents should, whether Oakland should remain in care with the maternal aunt and the parents work some services?
You know, I'm going to object to her giving an opinion.
What's the basis of your objection?
Well, she's not proffered as an expert.
Do you want to qualify her as an expert, Ms. Moore, or move on?
Well, Judge, I would just say that the rules allow lay people to give an expert opinion. And so lay people are allowed to give an opinion.
Well, she's not a layperson. She's a CPS worker. Do you want to?
I will. Let's talk about your training then real quick, Ms. Sonnenberg. How long have you been with CPS?
22 years.
Okay. And are you trained in a number of issues regarding child placement, for example?
Yes.
Are
In
you
the
trained?
interest of time, I withdraw my objection, Your Honor.
All right. Do you have an answer to the question, Ms. Sonnenberg?
And I'm sorry, Ms. Moore, can you repeat the question?
Sure. Based on your experience and qualifications, do you have an opinion about whether a monitored return would be best for Oakland at this time, or whether she should remain in the care of the maternal aunt and the parents work services?
I believe services would be appropriate at this time.
And a monitored return might be appropriate down the line, but you don't believe that at this point that it's appropriate now. Is that correct?
Correct.
I understood her answer, Ms. Moore.
Okay.
Do you have another question?
No, Your Honor, I'll pass the witness.
Questions of this witness, Ms. Keenum,
No, Your Honor.
Mr. Taylor?
Yes, Your Honor. Are you aware of any corporal punishment that Ms. Solomon has done? Any spankings that she's given Oakland?
No.
So is it just a fear that it might happen that you have?
Well, there were injuries to the other child, and that is a concern.
But none to Oakland, correct?
Not that I'm aware of.
You don't think that a monitored return would be basically monitor enough for something that's not happened? There's no danger that we can, that's palpable, that we have, evidence of. So a monitored return would be enough, wouldn't it, to keep an eye on this idea of corporal punishment?
I believe that Oakland should stay with the relative at this time, and that that would give us more time to see actual change in parenting style.
Well, wouldn't you be able to see more of her parenting style if Oakland's with her while you're monitoring? There's been no injury, as you call it, to Oakland. There's nothing there that would really make you believe that she's going to harm Oakland, is there?
Again, the other child had injuries, and that is a concern. I don't know if Oakland has had injuries before, and we can monitor interactions between the parent and child through conversations, through supervised visits.
Would you consider the injuries, as you call it, to Levi to be severe?
There were marks and bruises, so to me, that's severe.
Could that possibly have happened just with a spanking? a normal
Objection.
spanking, but
Calls for speculation.
well, this whole thing's about
I'll over-
speculation, Judge.
I'll
Thank you.
overrule your objection, ma'am. You may answer the question.
I'm sorry, can you repeat the question, Mr. Taylor?
Well, I guess I am asking you to speculate because all we're talking about is speculation that it could happen to Oakland. But you're aware of the 7 months that Jasmine went through all those classes and worked hard, right? You're aware of that.
That she did go through services, yes.
Yeah. So you have nothing that would lead you to believe that something is going to that really Oakland is in danger. There's nothing really there except for just a fear of something that possibly could happen. Is that right?
I'm going to object. That's argumentative.
His question is, what is the basis for the removal? Ms. Sonnenberg, that's what he's ultimately asking you. The entire basis for your opinion that a monitored return is not appropriate. Tell us the facts, every fact that you see it, as to what the basis is for not recommending a monitored return. That's what he's asking. Answer that question and we'll move on.
So throughout the FBSS case, even though Ms. Solomon did services, within a week, there were injuries to a child. So doing the checking off of services is not the same as making a change. And that's what we need to see.
So you don't want her to spank her children. Is that what you're saying?
As long as CPS is actively involved in a case, correct. We do not want parents to spank or caregivers to spank.
Okay. Is that the position of Child Protective Services at the department?
Yes.
That's a legal position of the department? Even though the family code allows it, actually says it's a duty of a parent.
Your Honor, I object as to argumentative.
Mr. Taylor, ask a question. I know what the law says, and I know you're going to have a great argument, but I don't want you to get your argument into the caseworker. Let's get facts from her, and then you can argue. Do you have any other questions for her?
No, Judge, I'm done with that.
Any other questions for Ms. Sonnenberg from anyone?
No, Your Honor.
No, Your Honor.
Other evidence, Ms. Moore?
No, Your Honor. I'll rest at this point.
Ms. Keenan?
Your Honor,
Evidence?
I call Jasmine Solomon. On March the 8th, 2023, were you assaulted by Luis Davila?
Yes.
Did that assault occur in Oakland's bedroom?
Yes.
And did that assault involve physical assault upon your body?
Yes.
Did it also involve sexual assault upon your body?
Yes.
And that was in Oakland's bedroom?
Yes, but Oakland was in our bedroom.
And in May, did you also get arrested for assault, family violence?
Yes, ma'am.
And who did you assault?
Lewis.
Pass the witness.
Questions, Mr. Taylor?
Yes, Your Honor. So you were in Oakland's bedroom, but Oakland was in your bedroom, correct?
Yes.
And you spent how long going through services and things regarding the children and those assaults? How long were you being monitored and taking classes?
From March until October.
And how long was Oakland with you during the time?
The whole time.
So was Ms. Erickson incorrect when she said part of the time, or was she ever removed from you?
No, Oakland was never removed from my care.
Okay. As far as these bruises go, on Levi, because I think that's what we're talking about. The fear for Oakland is about a spanking that Levi received, correct?
Yes.
Did did anybody at CPS caution you about Oakland during that time, or while you were doing those services? Did they seem to be afraid that Oakland was with you?
No, they didn't have any concerns with either of the children, actually.
Okay. How did it come about that, who called? I mean, no, I can't ask you that. How did this case start? How did the removal start? Somebody saw bruises on Levi's buttocks. Is that right?
So he had a bruise on his butt, but I think the main bruise that they saw was the circle bruise on his hip, which
Okay.
would be from him falling on the baseboard.
Okay.
And I
So-
guess they reported it.
So when the caseworker spoke about you denying spanking him, did that happen? Did you deny spanking him?
I said I hadn't spanked him with the belt in months. They do
Okay.
get spanked. Usually we spank with the hand or we put them in the corner.
All right. Was Levi acting out prior to this occurring?
Yes.
What was going on there?
He was just saying inappropriate things. He was cussing, he was hitting, he was arguing. He just absolutely would not listen. He spent most of his time after school in the corner.
Okay. How did you deal with that? What did you do as far as the cussing and that kind of thing with Levi?
I just put him in the corner. Lewis wasn't home. He was at work, so I just did the corner because that's usually what works best with me anyway.
Did you try to involve other people? Did you send
Yes.
a message? Okay, what'd you do?
I did. I texted Bill, I texted Lewis, I texted my mom, I texted Bill's sister Brittany, and I texted Bill's mom Amy. And I told them all that he had been acting out and that we can do corner time, he can get a spanking, or he can get no TV time. And everyone agreed, and then Bill just sent a thumbs up.
Okay. And you didn't get any other help or responses from anybody?
No.
Was it was a you were just informing them that there was something going on with him, and maybe they could help you
Yes.
watch or figure
Yes.
it out? Did you ever figure out what it was, or do you know what happened, or
No.
you think it was related to somebody at school or something of that nature?
I think it could have been any of his friends at school saying things that they hear at home. Like, obviously, 4-year-olds are going to repeat things that they hear from all kinds of different places. But there was also a little kid that had like autism, and that was Levi's best friend. And like in the mornings, the little boy would like always yell and scream and kick at his mom. So I think that Levi just kind of picked up on that, not knowing that like the little boy obviously had a problem. So that wasn't like a normal behavior for a normal kid.
Okay.
But
Yeah, so you,
I mean, it could have been a list of reasons. He's a toddler.
okay. You don't agree with spanking any child and putting bruises on them, correct?
Correct.
And that's not something that you do regularly or have done. You don't spank that hard on
No,
children.
I have even been told by like my parents that I don't spank them hard enough for them to even listen to me, and that's why they don't listen to me. So
Did you learn anything from that 7 months? Tell the court what you did for 7 months, what classes you took and what you had to do.
So we took a domestic violence class, which honestly, there's a lot of stuff that I have learned that I had no idea was even domestic violence, as far as like financial stuff and like stuff like that could be used as domestic violence. But with the parenting classes, like I learned that if you're talking level with your child, like face to face instead of standing over them, and like you're talking calmly, you're going to get your point across more. and they're going to understand and they're not going to freak out, because if you're yelling at them and you're screaming at them, obviously they're just going to shut down and they're not going to hear anything you're saying. And they recommend, like, not necessarily spanking them, but like you can do corner time. You can go set them in their room by themselves, like for 4 minutes, since he'd be 4, like a minute for each of his age. So Oakland would go to the corner for 3 minutes because she's 3. That way they don't forget how long they're in there and why they're in there. Really.
That you took those classes and you were engaged with them. You didn't just do it to get CPS out of your life. You actually learned some things.
Yes.
And you're glad you did it.
Yes, and I actually restarted my parenting classes again already.
Okay. Has your marriage gotten better because of it?
Honestly, this is the best that our relationship has ever been. And we are able to now sit and work things out calmly. If there's an argument or a disagreement or anything like that, we just sit and talk about it and it's over with. We agree to disagree, or we agree to agree, or whatever.
Now, you got angry about this when you got a call from Miss Erickson.
Yes.
Right? And that was put in the affidavit that you were screaming him in the background on the phone.
Yes.
when Lewis was on the phone. That happened?
Yes.
Okay. How soon after you were taken out of the family-based, system, did you get this call? How soon after?
7 days.
7 days.
Which is why I was so angry, because I feel like if they thought that my children were in harm's way, that they would have done something within the 8 months that they had. And correct me if I'm wrong, but an abuser is not just going to pick and choose when they abuse their victim.
When there was something told to you that was not, when something was said in the report here, the affidavit, that was not accurate as far as you refusing services, correct? I mean, what happened was, let me ask you this. What caused you to tell her that she just needs to get a court order? What happened? What made you say that to her?
Well, she wouldn't tell me what she needed to open an investigation for over the phone, and we were out of town at Oakland's birthday.
She wanted what? She wanted to speak to Oakland and Levi? What?
Yes.
Did she just want to speak with your children and she wouldn't tell you why?
No.
If she had told you why, would you have agreed that she could speak to them?
More than likely, yes.
But she refused to tell you why?
Yes.
Okay. That caseworker, Miss Erickson, are you aware of her being on your sister-in-law's case?
Yes.
Brandy Davia?
Mm-hmm.
And she was removed from that case, correct?
I believe so.
Judge, I'm going to object to the leading.
I'll sustain.
Okay. Do you feel like this is blown out of proportion?
I feel like it.
Again, I'll object to leading.
Overruled. Go ahead with your answer, ma'am.
I feel like it is blown out of proportion. And I get that there is a concern with the bruise on Levi and me saying that I had spanked him, but he is a toddler and he does climb trees. He does play outside all the time, and he is very active, and he's a toddler. I'm sure all of you have raised toddlers who have gotten bruises in weird spots, and it's looked crazy. So I feel like it's unfair that they got taken, and I feel like it's unfair that they're not allowing Oakland to come home, even under monitored, whatever it was called. Like, if y'all let her come home and y'all wanted to come see her every day, I wouldn't even care at this point.
So
like, if y'all wanted to sleep in the extra room, y'all can sleep in my extra room.
You're willing to do whatever you have to do,
I'm
to have
yes,
Oakland back. And that's because
Yes.
Oakland needs to be with her mother and her father, correct?
yes.
That's what.
Other questions, Ms. Moore?
Yes, Your Honor. Ms. Solomon, is this, I'm confused, is this or is this not a case of corporal punishment?
Yes.
It is. So you admit that you spanked him with Levi with a belt. Yeah, who are you looking at? Do you have someone there? Are you looking at somebody for some assistance?
No.
Okay. Did you spank him with a belt?
He has been spanked with the belt before, yes.
I'm talking about on this occasion, the bruises that were observed on Friday, the 13th of October. Did some of those come from you spanking him with a belt?
No, he had not been spanked with the belt at all that week.
All right. So all of those linear bruises came from him doing what, like a I don't know, a tightrope walk or something in a door frame?
So the only bruise that I know that for sure came from somewhere is the circle bruise that was on his hip from him climbing in the door frame, and he slipped and fell and landed right on his hip.
Okay, so you didn't spank him to cause any of the bruises from the 13th of October?
No, ma'am.
Okay, so this then is not a case of corporal punishment, is that right?
Yes, ma'am.
It is a case of corporal punishment?
No, I'm confused.
Well, okay, all along we've heard that this is a case of corporal punishment and that the parents have the right to punish their children, which is true, but you're saying that you didn't perform any corporal punishment that caused the bruising that was observed on October the 13th.
Yes, that's correct.
Okay. Did you tell Ms. Erickson that you are not going to stop whipping his ass, Levi's ass, and that he's not going to be a little heathen? Did you tell her that?
No,
You never said that to her at all.
I don't even use the word heathen.
Okay. What does Levi mean when he says that he's gotten busted?
Like he's got spanked.
Okay, with a belt?
He has been spanked with the belt before, but it can mean with our hand, with the belt.
And is it true that the busting from Mr. Davila hurts worse than the busting that you give him?
Lewis doesn't spank him any harder than I do, and Lewis has not spanked my child in months. Over months.
I'll pass the witness.
Other questions then, Ms. Keenum,
No, Your Honor.
Mr. Taylor?
Yes, Your Honor. Just want to wrap up. Jasmine, is there anything else you'd like to tell the court before we stop?
No,
Oh,
I don't think so.
Okay.
Let
That's
me
witness.
let me ask a couple of questions, Ms. Solomon.
Sure.
When was the last time that Levi was spanked with a belt?
I honestly don't remember. It's been a very long while since I've had to spank him with a belt. Because for a while the corner was working and then he just started acting out again, and that's when I sent everyone a group message to try and work together and figure out what's going on with him and get to the bottom of it.
When was the last time you spanked him, period?
I wouldn't know an exact date. I know it's
Did you
been.
see the bruising that they're talking about from the 13th? Did you see the bruising?
Yes, I have seen it.
Okay, so there was apparently there was a round bruise on his hip, and then there was a linear bruise across his buttocks. Did you see the linear bruises across his buttocks?
I seen it, but it was very faded.
Okay. So if those bruises were faded and the bruise on his hip was a fresher bruise, do you have any knowledge of where the linear bruises that seem to be older came from?
No, but it could be anything. I mean, him and Oakland fight all the time. They're always hitting each other with things. Really, it could have been absolutely anything.
Any other questions from anyone from Miss Solomon?
No, Your Honor.
All right, and other evidence from you, Miss Keenum?
Your Honor, I call Lisa Gaiman.
All right, Miss Gaiman, if you'll unmute, please. Miss Solomon, go ahead. Miss Gaiman, you've been sworn. Go ahead with questions, ma'am.
Please state your role in this.
All right,
case.
hold on one second. I want to be able to see both Mr. Davila and Miss Jasmine. Go ahead with the question.
Ms. Gaiman, what is your role in this case?
I'm appointed as the guardian ad litem. In this case, I work for Bluebonnet Casa.
And do you have a recommendation today for the court?
Yes, just from reading the affidavit and some other information that I've received regarding the police reports, excuse me, it is my opinion that it is best for Oakland to stay where she is at and Levi to stay where he's at. I have a huge problem with somebody who has been raped and physically assaulted going back to their abuser and having their children in that home. I realize she did go through the parenting and other things. There's a long CPS history with Jasmine, unfortunately, her being a victim. And I just think there's some mental health things that need to be addressed and some more services worked until I would feel safe for Oakland to be in the home.
No further questions, Your Honor.
Thank you. Mr. Taylor, questions?
Just briefly, Your Honor, what evidence do you have that there's mental instability?
In my opinion, again, as someone that is
what evidence
raped,
do you have?
I
What
have
evidence
her
do you
own
have?
words, her affidavit that this happened, the police report that says it happened, and she's sitting right next to him on the couch. So that's my evidence.
How does that make it dangerous for Oakland to be in the home when all we have is evidence that she's been a good mother to Oakland?
Well, that's your opinion. That's not my opinion. And
I'm
so
talking about evidence now, not opinions, evidence.
evidence, I'm saying, I don't have evidence that she's been a good mother. I have never seen her with her daughter.
Do you
All I
have
have
evidence
read
that
is
she's
the
been a bad
affidavit.
mother?
Yes,
Bad
when
mother.
there's, yes.
And what is that evidence?
The evidence is that you were raped and physically assaulted, and you are back in the home with the abuser and brought your children back into it, and that you went through parenting classes and all these other things. And here we have a corporal punishment case where a little boy was physically abused with bruises on his butt. That is the evidence that we have.
Well, you're characterizing it as physical abuse, and that's for the judge to do, isn't it?
Now, if I see bruises on a butt, I have the ability to think, I have an opinion, and my opinion can be that it's physical
All right.
abuse.
Pass the witness, Judge.
Ms. Moore, questions for Ms. Gaiman?
No questions, Your Honor.
Ms. Keenum, any other questions?
No, Your Honor.
Any other evidence, ma'am?
No, Your Honor.
Mr. Taylor, evidence?
No, Judge, I just ready to talk to you about it.
Other evidence, Ms. Moore?
No, Your Honor.
All right, so everyone's rested for the purpose of the determination of placement, request for the monitored return. We'll go ahead and have argument from Ms. Moore. Go
Judge,
ahead, ma'am.
I'm sorry, I didn't mean to interrupt.
That's fine.
I will just ask that the court not grant a monitored return at this time. I believe that there are services that the parents need to work, that the potential exists for something bad to happen, either if it's between the parents or if now that she's would be the only child in the home. I think the danger exists with regard to corporal punishment, although mom has said that this is not a corporal punishment case, that those bruises on Levi didn't come from corporal punishment. So the characterization of it, I don't think is appropriate, because I don't think we've gotten a straight answer or straight testimony from Ms. Solomon. But I would ask that the court not grant a monitored return at this time, that the court have the parents' work services, that their contact with Oakland be monitored at this point by either someone from the department or by the maternal aunt. Maybe a monitored return down the line would be appropriate, but the department will ask that the court not grant the monitored return at this time and keep Oakland's placement where it is.
All right, Mr. Taylor.
Your Honor, this is just conjecture. There's nothing to show any evidence at all.
Okay, let me interrupt right there. Let me interrupt right there. I have an affidavit that contains a statement from the child that says his mom busted him on the buttocks with her belt. So you can argue whatever you want, but that is not a legitimate argument when I have a statement from the child saying that that's what happened. So we do have evidence. It may not be accurate, but there is evidence, and it's not conjecture. So I understand your argument, but we do have evidence. So it may not be accurate, it may be wrong, but we have evidence to that effect. But go ahead.
Well, I'm talking about Oakland. There's nothing that says there's any problem with Oakland whatsoever. And the reason I've been using corporal punishment is because what the child said. I mean, that's worst case scenario here. That it had a spanking. That's worst case. My client says that she didn't spank him anytime lately, but so for me, that's just worst case scenario. That there might have been a spanking that caused that. We don't know who did it. I mean, he was in school too. There was a substitute teacher, the one that made the
Judge, I'm going to object that he's arguing facts that have not been brought into evidence.
All right, I'll sustain this to that. Go ahead, Mr. Taylor, with your argument.
Judge, the right thing to do here is to stop the bleeding on this poor little girl. I mean, she needs to be with her mother. Her mother takes care of her. She loves her. She gave birth to her. She's never injured her. She didn't. We characterizing these bruises as injury. I disagree with that. I think Your Honor is going to disagree with me. But we're not talking about a severe case of brutal beating. We're talking about, at worst case, a spanking. And the bruises are too much. If my client's
are you arguing that your client did spank the child?
No, I'm arguing that worst case scenario, if that's what the court decides, then it doesn't make it necessary to keep Oakland away from her mom and her dad, because there's nothing to show any danger at all to Oakland. There's just no evidence of it. That's the conjecture I'm talking about, Judge. She didn't. We don't know. There's no testimony. There's no evidence that she even spanked Oakland. They didn't elicit anything like that. It's just, we're talking about Levi, and my client did the right thing by not arguing about Levi, because he's with his father, and that's good. She's happy that he's safe. She really does care about these kids, and I think that should come through. A monitored return is the least restrictive thing to do here. There's no reason to keep Oakland away from her mom and dad right now, Judge. There's no danger to that child. There's been no showing of that. And I think that we're doing the right thing by monitoring the return, because everybody will be happy in the end. And my client probably learn some more because she's willing to. And I think those kind of things should come through for you, Judge. That, we're right in the beginning here. That was our first blush at this. And I think that's what we should do. Thank you. That's all I have.
Ms. Keenan.
Your Honor, I'm in agreement with the department and the guardian ad litem.
All right. Thank you. Ms. Sonnenberg, will you unmute? You're going to be the caseworker, is that correct?
Correct.
With what you know so far in the case, what services do you feel like the parents are going to be benefited from having?
Well, just from talking with Miss Solomon and reading the documentation, I know that she has been through parenting already, but she can go through another parenting class. I don't think that's a bad idea. And also for Mr. Davila, she has talked about already completing domestic violence classes and learning from those. However, there may be some type of maybe healthy relationships kind of service that we can look into. I think definitely visitation. Those would be my starting point, Your Honor.
Okay, so what specific? Okay, so they've just completed their FPSS case, and I can't remember when the parenting classes and the domestic violence classes ended. I'm not sure if I've heard that information or not, but I would think. Are you telling me that you would want some different or more intense or different curriculum parenting classes and domestic violence classes?
Yes, Your Honor.
And specifically, I think the allegation is, and as Mr. Taylor said, I agree that we went through there was an issue. We've gone through the 7-month, however long FBSS case. They successfully completed parenting and the domestic violence and everything else. And that's a significant amount of reasonable efforts made on behalf of the department. And then within 7 days, I guess it is, we have this bruise, which I believe to be from spanking with a belt, as the child has indicated. It's a different time frame bruise from the bruise on the hip. It appears from the limited amount of evidence that I have. And so it seems to me like Ms. Solomon is not telling me the truth. We didn't even hear from Mr. Davila at all. What specifically can we address with that particular issue and get it resolved quickly? Okay, we don't need to stick around for 6 months or a year. Either Ms. Solomon is going to quit spanking her child with the belt, or Mr. Davila is, and they're going to tell the truth, or they're not. How can we address that specifically so we can get Oakland back in the home promptly and close the case, or remove the children and terminate the parents' rights because they won't stop lying? What do we do?
Oh, I'm sorry. Go ahead.
My recommendation would be anger management and counseling.
Okay, so I was about to ask about counseling. Is that I don't really know that a parenting class or domestic violence class is going to be beneficial to either parent. I think anger management seems to be appropriate. When someone is on the phone with a government official and mad enough to scream and say my effing kids, but not say effing, just say the word kids, that is a significant anger issue that needs to be addressed, which I think is in line with spanking a 4-year-old boy too hard with a belt. So let's get something targeted. I don't want her or him to go through another cycle of parenting and domestic violence. I think they need to have intense counseling that will be in conjunction with anger management. I don't know about an anger management class, but just some intense counseling to realize how I deal with my anger issues and maybe the importance of telling the truth to the court. My guess is, and I'm speculating, that if Miss Solomon had said, yes, I spanked him with a belt, and obviously I spanked him too hard because he's got bruises, and I understand that was wrong, and yeah, let's work together and get this resolved, things would be different than they are now. That's my guess. So, but what beyond specific targeted counseling as to those areas are you going to recommend for your service plan?
Your Honor, I'm still assessing, so I haven't created or started creating the family plan yet with the parents. I will definitely, as the court has ordered, have counseling on there with an anger management component if there's not an anger management separate class. I think at this point I would ask for individual counseling rather than couples counseling, because there is that history of domestic violence. I do think it would be wisest to start them in their individual counseling.
So do we have someone available that can counsel both of them individually about these specific targeted issues, get that started quickly, and get us a recommendation back from that counselor promptly?
Your Honor, may I ask? I mean, wouldn't a psychological be in order in this case to see what recommendations are made?
Perhaps. I understand that. I'm talking about specific counseling that needs to start immediately. Do we have that availability, Ms. Sonberg?
I will make that happen.
Okay. So I'm going to, we've already had an agreement as a temporary managing conservatorship. I'm going to have the child remain in her current placement. We'll be back for our hearing, as I've already said, on December 20th. I definitely want to have a service plan that's going, as far as I'm concerned, the most important thing is for them to have individual counseling with a significant anger management aspect to that. Psychological would probably be in line for both parents. So that's what we need to get done. I don't think that Oakland needs to stay out of her home permanently. And I want her to get back to her mom and dad as soon as possible. And I know that they love both of their kids very, very much. But look, we had 7 months of process that y'all worked hard and successfully completed. And then we had this event. And it's troubling to me because I don't feel like you're telling me the truth about what happened. Okay. And that is the most troubling aspect to me. People can make mistakes. People can lose their temper. People can act out inappropriately because of that. At least I think, Ms. Solomon, you believe that people can do that and then change, or otherwise you wouldn't still be with Mr. Davila. Okay. I think that's what happened. And I think if you'd have come in here and said that and been, and I say this all the time in my court, brutally honest with everything, we'd be here differently. But we got to reset where I can trust both of you to tell me the truth, believe your kids, and get to a place where I'm not going to be concerned about you losing your temper in an event happening. Okay? So that's my order. I want that therapy to start immediately. We've got about 5 weeks, I guess, or so until we come back for our next hearing. We're talking about the holidays. Let's get that started promptly, and we're going to be well back on our way to doing that. Now, I've made a decision about what I thought about what happened. Maybe I made the wrong decision. Maybe I am completely off base as to what happened. That is water under the bridge. We got to turn and face forward and figure out a way where we can get Oakland back in your home and get towards closing the case. So my suggestion is work closely with your caseworker, with your CASA, be brutally honest, and be especially honest with your counselor so that person can say, hey, a mistake was made, but I feel confident that moving forward, we're not going to have to worry about this again. That's what I'm hoping we can do. Those are my orders and findings. So we'll be back on December 20th at 9:30 to discuss all those issues.